Hello, everyone. Today's case is Furman v. Georgia. This is a Supreme Court case that tackled the death penalty, and they had a very splintered decision. I think there's like 9 separate opinions in this, so let's see what they said. Imposition and carrying out of death penalty in these cases held to constitute cruel and unusual punishment in violation of the 8th and 14th Amendments. Per curiam, petitioner number 695003 was convicted of murder in Georgia and was sentenced to death pursuant to Georgia Code subsection 26 1005. Petitioner number 695030 was convicted of rape in Georgia and was sentenced to death pursuant to Georgia Code subsection 26 1302. Petitioner in number 695031 was convicted of rape in Texas and was sentenced to death pursuant to Texas Penal Code, Article 1189. Certiorari was granted, limited to the following question. Does the imposition and carrying out of the death penalty in these cases constitute cruel and unusual punishment in violation of the 8th and 14th Amendments? The court holds that the imposition and carrying out of the death penalty in these cases constitute cruel and unusual punishment in violation of the 8th and 14th Amendments. The judgment in each case is therefore reversed insofar as it leaves undisturbed the death sentence imposed, and the cases are remanded for further proceedings. So ordered. Mr. Justice Douglas, Mr. Justice Brennan, Mr. Justice Stewart, Mr. Justice White, Mr. Justice Marshall have filed separate opinions in support of the judgment. The Chief Justice, Justice Blackmun, Powell, and Rehnquist have filed separate dissenting opinions. Mr. Justice Douglas concurring. In these cases, the death penalty was imposed, one of them for murder and 2 for rape. In each, the determination of whether the penalty should be death or a lighter punishment was left by the state to the discretion of the judge or of the jury. In each of the 3 cases, the trial was to a jury. They are here on petitions for certiorari, which we granted limited to the question whether the imposition and execution of the death penalty constitute cruel and unusual punishment within the meaning of the 8th Amendment as applied to the states by the 14th. I vote to vacate each judgment, believing that the exaction of the death penalty does violate the 8th and 14th Amendments. That the requirements of due process ban cruel and unusual punishment is now settled. It is also settled that the proscription of cruel and unusual punishments forbids the judicial imposition of them, as well as their imposition by the legislature. Congressman Bingham, in proposing the 14th Amendment, maintained that the privileges or immunities of citizens of the United States, as protected by the 14th Amendment, included protection against cruel and unusual punishments. Many instances of state injustice and oppression have already occurred in the state legislation of this Union, of flagrant violations of the guaranteed privileges of citizens of the United States, for which the national government furnished and could furnish by law no remedy whatever. Contrary to the expressed letter of your Constitution, cruel and unusual punishments have been inflicted under state laws within this Union upon citizens, not only for crimes committed, but for sacred duty done, for which and against which the government of the United States had provided no remedy and could provide none. Whether the privileges and immunities route is followed or the due process route, the result is the same. It has been assumed in our decisions that punishment by death is not cruel unless the manner of execution can be said to be inhuman and barbarous. It is also said in our opinions that the proscription of cruel and unusual punishments is not fastened to the obsolete, but may acquire meaning as public opinion becomes enlightened by a humane justice. A like statement was made in Trop v. Dulles, that the 8th Amendment must draw its meaning from the evolving standards of decency that mark the progress of a maturing society. The generality of a law inflicting capital punishment is one thing. What may be said of the validity of a law on the books and what may be done with the law in its application do, or may, lead to quite different conclusions. It would seem to be incontestable that the death penalty inflicted on one defendant is unusual if it discriminates against him by reason of his race, religion, wealth, social position, or class, or if it is imposed under a procedure that gives room for the play of such prejudices. There is evidence that the provision of the English Bill of Rights of 1689, from which the language of the Eighth Amendment was taken, was concerned primarily with selective or irregular application of harsh penalties, and that its aim was to forbid arbitrary and discriminatory penalties of a severe nature. Following the Norman conquest of England in 1066, the old system of penalties, which ensured equality between crime and punishment, suddenly disappeared. By the time systematic judicial records were kept, its demise was almost complete. With the exception of certain grave crimes for which the punishment was death or outlawry, the arbitrary fine was replaced by a discretionary amercement. Although amercement's discretionary character allowed the circumstances of each case to be taken into account and the level of cash penalties to be decreased or increased accordingly, the amercement presented an opportunity for excessive or oppressive fines. The problem of excessive amercement became so prevalent that 3 chapters of the Magna Carta were devoted to their regulation. Maitland said of Chapter 14 that very likely there was no clause in the Magna Carta more grateful to the mass of the people. Chapter 14 clearly stipulated as fundamental law a prohibition of excessiveness in punishments. A free man shall not be amerced for a trivial offense except in accordance with the degree of the offense, and for a serious offense he shall be amerced according to its gravity, saving his livelihood, and a merchant likewise saving his merchandise. In the same way, a villain shall be amerced saving his wainage. If they fall into our mercy. And none of the aforesaid amercements shall be imposed except by the testimony of reputable men of the neighborhood. The English Bill of Rights, enacted December 16, 1689, stated that excessive bail ought not to be required, nor excessive fines imposed, nor cruel and unusual punishment inflicted. These were the words chosen for our Eighth Amendment. A like provision had been in Virginia's Constitution in 1776 and in the constitutions of 7 other states. The Northwest Ordinance, enacted under the Articles of Confederation, included a prohibition of cruel and unusual punishments. But the debates of the First Congress on the Bill of Rights throw little light on its intended meaning. All that appears is the following. Mr. Smith of South Carolina objected to the words "nor cruel and unusual punishments," the import of them being too indefinite. Mr. Livermore, the clause seems to express a great deal of humanity, on which account I have no objection to it. But as it seems to have no meaning in it, I do not think it necessary. What is meant by the terms excessive bail? Who are to be the judges? What is understood by excessive fines? It lies with the court to determine. No cruel and unusual punishment is to be inflicted. It is sometimes necessary to hang a man. Villains often deserve whipping and perhaps having their ears cut off. But are we in future to be prevented from inflicting these punishments because they are cruel? If a more lenient mode of correcting vice and deterring others from the commission of it could be invented, it would be very prudent in the legislature to adopt it. But until we have some security that this will be done, we ought not to be restrained from making necessary laws by any declaration of this kind. The words cruel and unusual certainly include penalties that are barbaric, but the words, at least when read in light of the English proscription against selective and irregular use of penalties, suggest that it is cruel and unusual to apply the death penalty or any other penalty. Selectively to minorities whose numbers are few, who are outcasts of society, who are unpopular, but whom society is willing to see suffer through it, though it would not countenance general application of the same penalty across the board. The court in Magatha v. California noted that in this country there was almost from the beginning a rebellion against the common law rule imposing a mandatory death sentence on all convicted murderers. The first attempted remedy was to restrict the death penalty to defined offenses such as premeditated murder. But juries took the law into their own hands and refused to convict on the capital offense. In order to meet the problem of jury nullification, legislatures did not try, as before, to refine further the definition of capital homicides. Instead, they adopted the method of forthrightly granting juries the discretion which they had been exercising in fact. The court concluded, in light of history, experience, and the present limitations of human knowledge, we find it quite impossible to say that committing to the untrammeled discretion of the jury the power to pronounce life or death in capital cases is offensive to anything in the Constitution. The court refused to find constitutional dimensions in the argument that those who exercise their discretion to send a person to death should be given standards by which that discretion should be exercised. A recent witness at the hearings before Subcommittee Number 3 of the House Committee on the Judiciary, Ernst Vandenhag, testifying on H.R. 8414, stated, "Any penalty, a fine, imprisonment, or the death penalty, could be unfairly or unjustly applied. The vice in this case is not in the penalty, but in the process by which it is inflicted. It is unfair to inflict unequal penalties on equally guilty parties, or on any innocent parties, regardless of what the penalty is." But those who advanced that argument overtook Magatha. We are now imprisoned in the Magatha holding. Indeed, the seeds of the present cases are in Magatha. Juries or judges, as the case may be, have practically untrammeled discretion to let an accused live or insist that he die. Mr. Justice Field, dissenting in O'Neill v. Vermont, said, "The state may, indeed, make the drinking of one drop of liquor an offense to be punished by imprisonment, but it would be an unheard of cruelty if it should count the drops in a single glass and make thereby 1,000 offenses, and thus extend the punishment for drinking the single glass of liquor to an imprisonment of almost indefinite duration. What the legislature may not do for all classes uniformly and systematically, a judge or jury may not do for a class that prejudice sets apart from the community. There is increasing recognition of the fact that the basic theme of equal protection is implicit in cruel and unusual punishments. A penalty should be considered unusually imposed if it is administered arbitrarily or indiscriminately. The same authors add that the extreme rarity with which applicable death penalties provisions are put to use raises a strong inference of arbitrariness. The President's Commission on Law Enforcement and Administration of Justice recently concluded. Finally, there is evidence that the imposition of the death sentence and the exercise of dispensing power by the courts and the executive follow discriminatory patterns. The death sentence is disproportionately imposed and carried out on the poor, the African American, and the members of unpopular groups. A study in capital cases in Texas from 1924 to 1968 reached the following conclusions. Application of the death penalty is unequal. Most of those executed were poor, young, and ignorant. Although there may be a host of factors other than... Oh, that's a footnote. 75 of the 460 cases involved co-defendants who, under Texas law, were given separate trials. In several instances where a white and an African American were co-defendants, the white was sentenced to life imprisonment on a term of years, and the African American was given the death penalty. Another ethnic disparity is found in the type of sentence imposed for rape. The African American convicted of rape is far more likely to get the death penalty than a term sentence, whereas whites and Latins are far more likely to get a term sentence than the death penalty. Warden Lewis E. Laws of Sing Sing said, "Not only does capital punishment fail in its justification, but no punishment could be invented with so many inherent defects. It is an unequal punishment in the way it is applied to the rich and to the poor. The defendant of wealth and position never goes to the electric chair or to the gallows. Juries do not intentionally favor the rich. The law is theoretically impartial. But the defendant with ample means is able to have his case presented with every favorable aspect, while the poor defendant often has a lawyer assigned by the court. Sometimes such assignment is considered part of political patronage. Usually the lawyer assigned has had no experience whatever in a capital case." Former Attorney General Ramsey Clark had said, "It is the poor, the sick, the ignorant, the powerless, and the hated who are executed. One searches our chronicles in vain for the execution of any member of the affluent strata of this society. The Leopolds and Lobes are given prison terms, not sentenced to death." Jackson, a black, convicted of the rape of a white woman, was 21 years old. A court-appointed psychiatrist said that Jackson was of average education and average intelligence, and that he was not an imbecile or schizophrenic or psychotic, that his traits were the product of environmental influences, and that he was competent to stand trial. Jackson had entered the house after the husband left for work. He held scissors against the neck of the wife, demanding money. She could find none, and a struggle ensued for the scissors, a battle which she lost, and she was then raped. Jackson, keeping the scissors pressed against her neck. While there did not appear to be any long-term traumatic impact on the victim, she was bruised and abrased in the struggle but was not hospitalized. Jackson was a convict who had escaped from a work gang in the area, a result of a 3-year sentence for auto theft. He was at large for 3 days, and during that time had committed several other offenses: burglary, auto theft, and assault and battery. Furman, a black, killed a householder while seeking to enter the home at night. Furman shot the deceased through the door. He was 26 years old and had finished the 6th grade in school. Pending trial, he was committed to the Georgia Central State Hospital for a psychiatric examination on his plea of insanity, tendered by court-appointed counsel. The superintendent reported that a unanimous staff diagnostic conference had concluded that this patient should retain his present diagnosis of mental deficiency, mild to moderate, with psychotic episodes associated with convulsive disorder. The physicians agreed that at present the patient is not psychotic, but he is not capable of cooperating with his counsel in the preparation of his defense. And the staff believe that he is in need of further psychiatric hospitalization and treatment. Later, the superintendent reported that the staff diagnosis was mental deficiency, mild to moderate, with psychotic episodes associated with convulsive disorder. He concluded, however, that Furman was not psychotic at present, knows right from wrong, and is able to cooperate with his counsel in preparing his defense. Branch, a black, entered the rural home of a 65-year-old widow, a white, while she slept and raped her, holding his arm against her throat. Thereupon, he demanded money, and for 30 minutes or more, the widow searched for money, finding little. As he left, Jackson said if the widow told anyone what happened, he would return and kill her. The record is barren of any medical or psychiatric evidence showing injury to her as a result of Branch's attack. He had previously been convicted of felony theft and found to be a borderline mental deficient and well below the average IQ of Texas prison inmates. He had the equivalent of 5.5 years of grade school education. He had a dull intelligence and was in the lowest 4th percentile of his class. We cannot say from facts disclosed in these records that these defendants were sentenced to death because they were black. Yet our task is not restricted to an effort to divine what motives impelled these death penalties. Rather, we deal with a system of law and of justice that leaves to the uncontrolled discretion of judges or juries the determination whether defendants committing these crimes should die or be in prison. Under these laws, no standards govern the selection of the penalty. People live or die, dependent on the whim of one man or of 12. Irving Brandt has given a detailed account of the bloody assizes, the reign of terror that occupied the closing years of the rule of Charles II and the opening years of the regime of James II. The Lord Chief Justice was George Jeffreys. Nobody knows how many hundreds of men, innocent or of unproven guilt, Jeffreys sent to their deaths in the pseudo-trials that followed Monmouth's feeble and stupid attempt to seize the throne. When the ordeal ended, scores had been executed and 1,260 were awaiting the hangman in 3 counties. To be absent from home during the uprising was evidence of guilt. Mere death was considered much too mild for the villagers and farmers rounded up in these raids. The directions of a high sheriff were to provide an axe, a cleaver, a furnace or cauldron to boil their heads and quarters, and soil to boil therewith, half a bushel to each traitor, and tar to tar them with, and a sufficient number of spears and poles to fix their heads and quarters along the highways. One could have crossed a good part of northern England by their guidance. The story of the bloody assizes widely known to Americans, helped to place constitutional limitations on the crime of treason and to produce a bar against cruel and unusual punishments. But in the polemics that led to the various guarantees of freedom, it had no place compared with the tremendous thrust of the trial and execution of Sidney. The hundreds of judicial murders committed by Jeffries and his fellow judges were totally inconceivable in a free American republic. But any American could imagine himself in Sidney's place, executed for putting on paper in his closet words that later on came to express the basic principles of Republican government. Unless barred by fundamental law, the legal rulings that permitted this result could easily be employed against any person whose political opinions challenged the party in power. Those who wrote the Eighth Amendment knew what price their forebears had paid for a system based not on equal justice, but on discrimination. In those days, the target was not the blacks or the poor, but the dissenters, those who opposed absolutism in government, who struggled for a parliamentary regime, and who opposed government's recurring efforts to foist a particular religion on the people. But the tool of capital punishment was used with vengeance against the opposition and those unpopular with the regime. One cannot read this history without realizing that the desire for equality was reflected in the ban against cruel and unusual punishments contained in the Eighth Amendment. In a nation committed to equal protection of the laws, there is no permissible caste aspect of law enforcement. Yet we know that the discretion of judges and juries in imposing the death penalty enables the penalty to be selectively applied, feeding prejudices against the accused if he is poor and despised and lacking political clout, or if he is a member of a suspect or unpopular minority, and saving those who, by social position, may be in a more protected position. In ancient Hindu law, a Brahmin was exempt from capital punishment, and under that law, generally in the law books, punishment increased in severity as social status diminished. We have, I fear, taken in practice the same position, partially as a result of making the death penalty discretionary and partially as a result of the ability of the rich to purchase the services of the most respected and most resourceful legal talent in the nation. The high service rendered by the cruel and unusual punishment clause of the Eighth Amendment is to require legislatures to write penal laws that are even-handed, non-selective, and non-arbitrary, and to require judges to see to it that general laws are not applied sparsely, selectively, and spottily to unpopular groups. A law that stated that anyone making more than $50,000 would be exempt from the death penalty would plainly fall, as would a law that in terms said that blacks, those who never went beyond the 5th grade in school, those who made less than $3,000 a year, or those who were unpopular or unstable, should be the only people executed. A law which, in the overall view, reaches that result in practice, has no more sanctity than a law which, in terms, provides the same. Thus, these discretionary statutes are unconstitutional in their operation. They are pregnant with discrimination, and discrimination is an ingredient not compatible with the idea of equal protection of the laws that is implicit in the ban on cruel and unusual punishments. Any law which is non-discriminatory on its face may be applied in such a way as to violate the Equal Protection Clause of the 14th Amendment. Such conceivably might be the fate of a mandatory death penalty, where equal or lesser sentences were imposed on the elite, a harsher one on the minorities or members of the lower castes. Whether a mandatory death penalty would otherwise be constitutional is a question I do not reach. I concur in the judgment. Mr. Justice Brennan concurring. The question presented in these cases is whether death is today a punishment for crime that is cruel and unusual, and consequently, by virtue of the 8th and 14th Amendments, beyond the power of the state to inflict. Almost a century ago, this court observed that difficulty would attend the effort to define with exactness the extent of the constitutional provision which provides that cruel and unusual punishments shall not be inflicted. Less than 15 years ago, it was again noted that the exact scope of the constitutional phrase cruel and unusual has not been detailed by this court. Those statements remain true today. The Cruel and Unusual Punishments Clause, like the other great clauses of the Constitution, is not susceptible of precise definition. Yet we know that the values and ideals it embodies are basic to our scheme of government. As we know also that the clause imposes upon this court the duty when the issue is properly presented, to determine the constitutional validity of a challenged punishment, whatever that punishment may be. In these cases, that issue confronts us, and the task of resolving it is inescapably ours. We have very little evidence of the framers' intent in including the cruel and unusual punishments clause among those restraints upon the new government enumerated in the Bill of Rights. The absence of such a restraint from the body of the Constitution was alluded to, so far as we know, in the debates of only two of the state ratifying conventions. In the Massachusetts Convention, Mr. Holmes protested. What gives an additional glare of horror to these gloomy circumstances is the consideration that Congress have to ascertain, point out, and determine what kind of punishments shall be inflicted on persons convicted of crimes. They are nowhere restrained from inventing the most cruel and unheard of punishments and annexing them to crimes, and there is no constitutional check on them but that racks and gibbets may be among the most mild instruments of their discipline. Holmes' fear that Congress would have unlimited power to prescribe punishments for crimes was echoed by Patrick Henry at the Virginia Convention. Congress, from their general powers, may fully go into business of human legislation. They may legislate in criminal cases, from treason to the lowest offense, petty larceny. They may define crimes and prescribe punishments in the definition of crimes. I trust they will be directed by what wise representatives ought to be governed by. But when we come to punishments, no latitude ought to be left, nor dependence put on the virtue of representatives. What says our Virginia Bill of Rights? That excessive bail ought not to be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. Are you not, therefore, now calling on those gentlemen who are to compose Congress to define punishments without this control? Will they find sentiments there similar to this Bill of Rights? You let them loose, you do more, you depart from the genius of your country. In this business of legislation, your members of Congress will loose the restriction of not imposing excessive fines, demanding excessive bail, and inflicting cruel and unusual punishments. These are prohibited by your Virginia Declaration of Rights. What has distinguished our ancestors? That they would not admit of tortures or cruel and barbarous punishment. These two statements shed some light on what the framers meant by cruel and unusual punishments. Holmes referred to the most cruel and unheard of punishments, Henry to tortures or cruel and barbarous punishment. It does not follow, however, that the framers were exclusively concerned with prohibiting torturous punishments. Holmes and Henry were objecting to the absence of a Bill of Rights, and they cited to support their objections the unrestrained legislative power to prescribe punishments for crimes. Certainly, we may suppose that they invoke the specter of the most drastic punishments a legislature might devise. In addition, it is quite clear that Holmes and Henry focused wholly upon the necessity to restrain the legislative power, because they recognized that Congress have to ascertain, point out, and determine what kinds of punishments shall be inflicted on persons convicted of crimes. They insisted that Congress must be limited in its power to punish. Accordingly, they called for a constitutional check that would ensure that when we came to punishments, no latitude ought to be left, nor dependence put on the virtue of representatives. The only further evidence of the framers' intent appears from the debates in the first Congress on the adoption of the Bill of Rights. As the court noted in Weems v. United States, the cruel and unusual punishments clause received very little debate. The extent of the discussion by two opponents of the clause in the House of Representatives was this. Mr. Smith of South Carolina objected to the words "nor cruel and unusual punishments," the import of them being too indefinite. Mr. Livermore, the Eighth Amendment seems to express a great deal of humanity, on which account I have no objection to it. But as it seems to have no meaning in it, I do not think it necessary. No cruel and unusual punishment is to be inflicted. It is sometimes necessary to hang a man, villains often deserving a whipping, and perhaps having their ears cut off. But are we in future to be prevented from inflicting these punishments because they are cruel? If a more lenient mode of correcting vice and deterring others from the commission of it could be invented, it would be very prudent in the legislature to adopt it. But until we have some security that this will be done, we ought not to be restrained from making necessary laws by any declaration of this kind. The question was put on the Eighth Amendment, and it was agreed to by a considerable majority. Livermore thus agreed with Holmes and Henry that the Cruel and Unusual Punishments Clause imposed a limitation upon the legislative power to prescribe punishments. However, in contrast to Holmes and Henry, who were supporting the clause, Livermore, opposing it, did not refer to punishments that were considered barbarous and torturous. Instead, he objected that the clause might someday prevent the legislature from inflicting what were then quite common and, in his view, necessary punishments: death, whipping, and ear cropping. The only inference to be drawn from Livermore's statement is that the considerable majority was prepared to run that risk. No member of the House rose to reply that the clause was intended merely to prohibit torture. Several conclusions thus emerged from the history of the adoption of the clause. We know that the framers' concern was directed specifically at the exercise of legislative power. They included in the Bill of Rights a prohibition upon cruel and unusual punishment, precisely because the legislature would otherwise have had the unfettered power to prescribe punishments for crimes. Yet we cannot now know exactly what the framers thought cruel and unusual punishments were. Certainly, they intended to ban torturous punishments, but the available evidence does not support the further conclusion that only torturous punishments were to be outlawed. As Livermore's comments demonstrate, the framers were well aware that the reach of the clause was not limited to the proscription of unspeakable atrocities, nor did they intend simply to forbid punishments considered cruel and unusual at the time. The import of the clause is indeed indefinite, and for good reason. A constitutional provision is enacted, it is true, from an experience of evils, but its general language should not therefore be necessarily confined to the form that evil had theretofore taken. Time works changes, bringing into existence new conditions and purposes. Therefore, a principle to be vital must be capable of wider application than the mischief which gave it the birth. It was almost 80 years before this court had occasion to refer to the clause. These early cases, as the court pointed out in Weems v. United States, did not undertake to provide an exhaustive definition of cruel and unusual punishments. Most of them proceeded primarily by looking backwards for examples by which to fix the meaning of the clause, concluding simply that a punishment would be cruel and unusual if it were similar to punishments considered cruel and unusual at the time the Bill of Rights was adopted. In Wickerson v. Utah, for instance, the court found it safe to affirm that punishments of torture and all others in the same line of unnecessary cruelty are forbidden. The punishment of torture, which the court labeled atrocities, were cases where the criminal was emboweled alive, beheaded, and quartered, and cases of public dissection and burning alive. Similarly, in re Kemmler, the court declared that if the punishment prescribed for an offense against the laws of the state were manifestly cruel and unusual, as burning at the stake, crucifixion, breaking on the wheel, or the like, it would be the duty of the courts to adjudge such penalties to be within the constitutional prohibition. The court then observed, commenting upon the passage just quoted from Wilkerson v. Utah, and applying the manifestly cruel and unusual test, that punishments are cruel when they involve torture or lingering death, but the punishment of death is not cruel, within the meaning of that word as used in the Constitution. It implies there's something inhuman and barbarous, something more than the mere extinguishment of life. Had this historical interpretation of the Cruel and Unusual Punishments Clause prevailed, the clause would have been effectively read out of the Bill of Rights. As the court notes in Weems v. United States, this interpretation led Story to conclude that the provision would seem to be wholly unnecessary in a free government, since it is scarcely possible that any department of such a government should authorize or justify such atrocious conduct. And Cooley, in his book, Constitutional Limitations, said the court, apparently in a struggle between the effect to be given to ancient examples and the inconsequence of a dread of them in these enlightened times, hesitated to advance definite views. The result of a judicial application of this interpretation was not surprising. A state court, for example, upheld the constitutionality of the whipping post. In comparison with the barbarities of quartering, hanging in chains, castration, etc., it was easily reduced to insignificance. But this court in Weems decisively repudiated the historical interpretation of the clause. The court, returning to the intention of the framers, relied on the conditions which existed when the Constitution was adopted. And the framers knew that government by the people instituted by the Constitution would not imitate the conduct of arbitrary monarchs. The abuse of power might, indeed, be apprehended, but not that it would be manifested in provisions or practices which would shock the sensibilities of men. The clause then guards against the abuse of power, contrary to the implications in Wilkerson v. Utah and in Ex Rick Kembler. The prohibition of the clause is not confined to such penalties and punishment as were inflicted by the Stuarts. Although opponents of the Bill of Rights felt sure that the spirit of liberty could be trusted and that its ideals would be represented, not debased, by legislation, the framers disagreed. Patrick Henry and those who believed as he did would take no chances. Their predominant political impulse was distrust of power, and they insisted on constitutional limitations against its abuse. But surely they intended more than to register a fear of the forms of abuse that went out of practice with the Stuarts. Surely their jealousy of power had a saner justification than that. They were men of action, practical and sagacious, not beset with vain imagining, and it must have come to them that there could be exercises of cruelty by laws other than those which inflicted bodily pain or mutilation. With power in a legislature great, if not unlimited, to give criminal character to the actions of men, with power unlimited to fix terms of imprisonment, with what accompaniments they might, what more potent instrument of cruelty could be put into the hands of power? And it was believed that power might be tempted to cruelty. This was the motive of the clause, and if we are to attribute an intelligent providence to its advocates, we cannot think that it was intended to prohibit only practices like the Stuarts, or to prevent only an exact repetition of history. We cannot think that the possibility of a coercive cruelty being exercised through other forms of punishment was overlooked. The court in Weems thus recognized that this restraint upon legislatures possesses an expansive and vital character that is essential to the rule of law and the maintenance of individual freedom. Accordingly, the responsibility lies with the courts to make certain that the prohibition of the clause is enforced. Referring to cases in which prominence was given to the power of the legislature to define crimes and their punishment, the court said, "We concede the power in most of its exercises. We disclaim the right to assert a judgment against that of the legislature of the expediency of the laws, or the right to oppose the judicial power to the legislative power to define crimes and fix their punishments, unless that power encounters in its exercise a constitutional prohibition. In such case, not our discretion, but our legal duty, strictly defined and imperative in its direction, is invoked." In short, this court finally adopted the framers' view of the clause as a constitutional check to ensure that when we come to punishments, no latitude ought to be left nor dependence put on the virtue of representatives. That, indeed, is the only view consonant with our constitutional form of government. If the judicial conclusion that a punishment is cruel and unusual depended upon virtually unanimous condemnation of the penalty at issue, then, like no other constitutional provision, the clause's only function would be to legitimize advances already made by the other departments and opinions already the conventional wisdom. We know that the framers did not envision so narrow a role for this basic guarantee of human rights. The right to be free of cruel and unusual punishments, like the other guarantees of the Bill of Rights, may not be submitted to vote. It depends on the outcome of no elections. The very purpose of the Bill of Rights was to withdraw certain subjects from the vicissitudes of political controversy, to place them beyond the reach of majorities and officials, and to establish them as legal principles as to be applied by the courts. Judicial enforcement of the clause, then, cannot be evaded by invoking the obvious truth that legislatures have the power to prescribe punishments for crimes. Judicial enforcement of the clause, then, cannot be evaded by invoking the obvious truth that legislatures have the power to prescribe punishments for crimes. That is precisely the reason the clause appears in the Bill of Rights. The difficulty arises rather in formulating the legal principles to be applied applied by the courts when a legislatively prescribed punishment is challenged as cruel and unusual. In formulating those constitutional principles, we must avoid the insertion of judicial conception of wisdom or propriety. Yet we must not, in the guise of judicial restraint, abdicate our fundamental responsibility to enforce the Bill of Rights. Were we to do so, the Constitution would indeed be as easy of application as it would be deficient in efficacy and power. Its general principles would have little value to be converted by precedent into impotent and lifeless formulas. Rights declared in words might be lost in reality. The cruel and unusual punishments clause would become, in short, little more than good advice. Ours would indeed be a simple task, were we required merely to measure a challenged punishment against those that history has long condemned. That narrow and unwarranted view of the clause, however, was left behind with the 19th century. Our task today is more complex. We know that the words of the clause are not precise, and that their scope is not static. We know, therefore, that the clause must draw its meaning from the evolving standards of decency that mark the progress of a maturing society. That knowledge, of course, is but the beginning of the inquiry. In Trop v. Dulles, it was said that the question is whether a penalty subjects the individual to a fate forbidden by the principle of civilized treatment guaranteed by the clause. It was also said that a challenged punishment must be examined in light of the basic prohibition against inhuman treatment embodied in the clause. It was said finally that the basic concept underlying the clause is nothing less than the dignity of man. While the state has the power to punish, the clause stands to assure that this power be exercised within the limits of civilized standards. At bottom, then, the cruel and unusual punishments clause prohibits the infliction of uncivilized and inhuman punishments. The state, even as it punishes, must treat its members with respect for their intrinsic worth as human beings. A punishment is cruel and unusual, therefore, if it does not comport with human dignity. This formulation, of course, does not of itself yield principles of assessing the constitutional validity of particular punishments. Nevertheless, even though this court has had little occasion to give precise content to the clause, there are principles recognized in our cases and inherent in the clause sufficient to permit a judicial determination whether a challenged punishment comports with human dignity. The primary principle is that a punishment must not be so severe as to be degrading to the dignity of human beings. Pain certainly may be a factor in the judgment. The infliction of an extremely severe punishment will often entail physical suffering. Yet the framers also knew that there could be exercises of cruelty by laws other than those which inflicted bodily pain or mutilation. Even though there may be involved no physical mistreatment, no primitive torture, severe mental pain may be inherent in the infliction of a particular punishment. That indeed was one of the conclusions underlying the holding of the plurality in Trop v. Dulles, that the punishment of expatriation violates the clause. And the physical and mental suffering inherent in the punishment of cadena temporal was an obvious basis of the court's decision in Weems v. United States, that the punishment was cruel and unusual. More than the presence of pain, however, is comprehended in the judgment that the extreme severity of a punishment makes it degrading to the dignity of human beings. The barbaric punishments condemned by history, punishments which inflict torture such as the rack, the thumbscrew, the iron boot, the stretching of limbs, and the like, are of course attended with acute pain and suffering. When we consider why they have been condemned, however, we realize that the pain involved is not the only reason. The true significance of these punishments is that they treat members of the human race as non-human, as objects to be toyed with and discarded. They are thus inconsistent with the fundamental premise of the clause that even the vilest criminal remains a human being possessed of common human dignity. The infliction of an extremely severe punishment, then, like the one before the court in Weems v. United States, from which no circumstance of degradation was omitted, may reflect the attitude that the person punished is not entitled to recognition as a fellow human being. That attitude may be apparent apart from the severity of the punishment itself. In Louisiana ex rel. Francis v. Resweber, For example, the unsuccessful electrocution, although it caused mental anguish and physical pain, was the result of an unforeseeable accident. Had the failure been intentional, however, the punishment would have been, like torture, so degrading and indecent as to amount to a refusal to accord the criminal human status. Indeed, a punishment may be degrading to human dignity solely because it is a punishment. A state may not punish a person for being mentally ill, or a leper, or afflicted with a venereal disease, or for being addicted to narcotics. To inflict punishment for having a disease is to treat the individual as a diseased thing rather than as a sick human being. That the punishment is not severe in the abstract is irrelevant. Even 1 day in prison would be a cruel and unusual punishment for the crime of having a common cold. Finally, of course, a punishment may be degrading simply by reason of its enormity. A prime example is expatriation, a punishment more primitive than torture, for it necessarily involves a denial by society of an individual's existence as a member of the human community. In determining whether a punishment comports with human dignity, we are aided also by a second principle inherent in the clause, that the state must not arbitrarily inflict a severe punishment. This principle derives from the notion that the state does not respect human dignity when, without reason, it inflicts upon some people a severe punishment that it does not inflict upon others. Indeed, the very words cruel and unusual punishments imply condemnation of the arbitrary infliction of severe punishments, and as we now know, the English history of the clause reveals a particular concern with the establishment of a safeguard against arbitrary punishments. This principle has been recognized in our cases. In Wilkerson v. Utah, the court reviewed various treaties on military law in order to demonstrate that under the custom of war, shooting was a common method of inflicting the punishment of death. On that basis, the court concluded, cruel and unusual punishments are forbidden by the Constitution, but the authorities referred to treaties on military law are quite sufficient to show that the punishment of shooting as a mode of executing the death penalty for the crime of murder in the first degree is not included in that category within the meaning of the clause. Soldiers convicted of desertion or other capital military offenses are in the great majority of cases sentenced to be shot, and the ceremony of such occasions is given in great fullness by the writers upon the subjects of courts martial. The court thus upheld death by shooting so far as appears solely on the ground that it was a common method of execution. In Wilkerson v. Utah, as Wilkerson v. Utah suggests, when a severe punishment is inflicted, in the great majority of cases in which it is legally available, there is little likelihood that the state is inflicting it arbitrarily. If, however, the infliction of a severe punishment is something different from that which is generally done in such cases, there is a substantial likelihood that the state, contrary to the requirements of regularity and fairness embodied in the clause, is inflicting the punishment arbitrarily. This principle is especially important today. There is scant danger, given the political process in an enlightened democracy such as ours, that extremely severe punishments will be widely applied. The more significant function of the clause, therefore, is to protect against the danger of their arbitrary infliction. A third principle inherent in the clause is that a severe punishment must not be unacceptable to contemporary society. Rejection by society, of course, is a strong indication that a severe punishment does not comport with human dignity. In applying this principle, however, we must make certain that the judicial determination is as objective as possible. Thus, for example, Weems v. United States and Trop v. Dulles suggest that one factor that may be considered is the existence of the punishment in jurisdictions other than those before the court. Wilkerson v. Utah suggests that another factor to be considered is the historic usage of the punishment. Trop v. Dulles combined present acceptance with past usage by observing that the death penalty has been employed throughout our history, and in a day when it is still widely accepted, it cannot be said to violate the constitutional concept of cruelty. In Robinson v. California, which involved the infliction of punishment for narcotics addiction, the court went a step further, concluding simply that, in light of contemporary human knowledge, a law which made a criminal offense of such a disease would doubtless be universally thought to be an infliction of cruel and unusual punishment. The question under this principle, then, is whether there are objective indicators from which a court can conclude that contemporary society considers a severe punishment unacceptable. Accordingly, the judicial task is to review the history of a challenged punishment and to examine society's present practices with respect to its use. Legislative authorization, of course, does not establish acceptance. The acceptability of a severe punishment is measured not by its availability, for it might become so offensive to society as never to be inflicted, but by its use. The final principle inherent in the clause is that a severe punishment must not be excessive. A punishment is excessive under this principle if it is unnecessary. The infliction of a severe punishment by the state cannot comport with human dignity when it is nothing more than the pointless infliction of suffering. If there is a significantly less severe punishment adequate to achieve the purposes for which the punishment is inflicted, the punishment inflicted is unnecessary and therefore excessive. This principle first appeared in our cases in Mr. Justice Field's dissent in O'Neill v. Vermont. He there took the position that the clause is directed not only against punishments of the character mentioned, torturous punishments, but against all punishments which by their excessive length or severity are greatly disproportionate to the offense charged. The whole inhibition is against that which is excessive, either in the bail required or fine imposed, or punishment inflicted. Although the determination that a severe punishment is excessive may be grounded in the judgment that it is disproportionate to the crime. The more significant basis is that the punishment serves no penal purpose more effectively than a less severe punishment. This view of the principle was explicitly recognized by the court in Weems v. United States. There, the court, reviewing a severe punishment inflicted for the falsification of an official record, found that the highest punishment possible for a crime which may cause the loss of many thousands of dollars, and to prevent which the duty of the state should be as eager as to prevent the perversion of truth in a public document, is not greater than that which may be imposed for falsifying a single item of a public account. Stating that this contrast shows more than different exercises of legislative judgment, the court concluded that the punishment was unnecessarily severe in view of the purposes for which it was imposed. There are, then, 4 principles by which we may determine whether a particular punishment is cruel and unusual. The primary principle, which I believe supplies the essential predicate for the application of the others, is that a punishment must not, by its severity, be degrading to human dignity. The paradigm violation of this principle would be the infliction of a torturous punishment of the type that the clause has always prohibited. Yet it is unlikely that any state at this moment in history would pass a law providing for the infliction of such a punishment. Indeed, no such punishment has ever been before this court. The same may be said of the other principles. It is unlikely that this court will confront a severe punishment that is obviously inflicted in wholly arbitrary fashion. No state would engage in a reign of blind terror, nor is it likely that this court will be called upon to review a severe punishment that is clearly and totally rejected throughout society. No legislature would be able even to authorize the infliction of such a punishment. Nor, finally, is it likely that this court will have to consider a severe punishment that is patently unnecessary. No state today would inflict a severe punishment knowing that there was no reason whatever for doing so. In short, we are unlikely to have occasion to determine that a punishment is fatally offensive under any one principle. Since the Bill of Rights was adopted, this court has adjudged only 3 punishments to be within the prohibition of the clause. See Weems v. United States, 12 years in chains at hard and painful labor, Trop v. Dulles, expatriation, and Robinson v. California, imprisonment for narcotics addiction. Each punishment, of course, was degrading to human dignity, but of none could it be said conclusively that it was fatally offensive under one or the other of the principles. Rather, these cruel and unusual punishments seriously implicated several of the principles, and it was the application of the principles in combination that supported the judgment. That, indeed, is not surprising. The function of these principles, after all, is simply to provide means by which a court can determine whether a challenged punishment comports with human dignity. They are, therefore, interrelated, and in most cases, it will be their convergence that will justify the conclusion that a punishment is cruel and unusual. The test then will ordinarily be a cumulative one. If a punishment is unusually severe, if there is a strong probability that it is inflicted arbitrarily, if it is substantially rejected by contemporary society, and if there is no reason to believe that it serves any penal purpose more effectively than some less severe punishment, then the continued infliction of that punishment violates the command of the clause, that the state may not inflict inhuman and uncivilized punishments upon those convicted of crimes. The punishment challenged in these cases is death. Death, of course, is a traditional punishment, one that has been employed throughout our history, and its constitutional background is accordingly an appropriate subject of inquiry. There is, first, a textual consideration raised by the Bill of Rights itself. The Fifth Amendment declares that if a particular crime is punishable by death, a person charged with that crime is entitled to certain procedural protections. We can thus infer that the framers recognized the existence of what was then a common punishment. We cannot, however, make the further inference that they intended to exempt this particular punishment from the express prohibition of the Cruel and Unusual Punishments Clause. Nor is there any indication in the debates on the clause that a special exception was to be made for death. If anything, the indication is to the contrary, for Livermore specifically mentioned death as a candidate for future proscription under the clause. Finally, it does not advance analysis to insist that the framers did not believe that adoption of the Bill of Rights would immediately prevent the infliction of the punishment of death. Neither did they believe that it would immediately prevent the infliction of other corporal punishments that, although common at the time, are now acknowledged to be impermissible. There is also the consideration that this court has decided 3 cases involving constitutional challenges to particular methods of inflicting this punishment. In Wilkerson v. Utah and in X. re Kemmler, the court expressly, in both cases, the since rejected historical view of the clause, approved death by shooting and death by electrocution. In Wilkerson, the court concluded that shooting was a common method of execution. In Kemmler, the court held that the clause did not apply to the states. In Louisiana, Ex rel. Francis v. Resweber, the court approved a second attempt at electrocution after the first had failed. It was said that the 14th Amendment would prohibit by its due process clause execution by a state in a cruel manner, but that the abortive attempt did not make the subsequent execution any more cruel in the constitutional sense than any other execution. These 3 decisions thus reveal that the court, while ruling upon various methods of inflicting death, has assumed in the past that death was a constitutionally permissible punishment. Past assumptions, however, are not sufficient to limit the scope of our examination of this punishment today. The constitutionality of death itself, under the Cruel and Unusual Punishments Clause, is before this court for the first time. We cannot avoid the question by recalling past cases that never directly considered it. The question, then, is whether the deliberate infliction of death is today consistent with the command of the clause that the state may not inflict punishments that do not comport with human dignity. I will analyze the punishment of death in terms of the principles set out above, and the cumulative test to which they lead. It is a denial of human dignity for the state arbitrarily to subject a person to an unusually severe punishment that society has indicated it does not regard as acceptable, and that cannot be shown to serve any penal purpose for more effectively than a significantly less drastic punishment. Under these principles and this test, death is today a cruel and unusual punishment. Death is a unique punishment in the United States in a society that so strongly affirms the sanctity of life. Not surprisingly, the common view is that death is the ultimate sanction. This natural human feeling appears all about us. There has been no national debate about punishment, in general or by imprisonment, comparable to the debate about the punishment of death. No other punishment has been so continuously restricted, nor has any state yet abolished prisons, as some have abolished this judgment. And those states that still inflicts death reserve it for the most heinous crimes. Juries, of course, have always treated death cases differently, as have governors exercising their commutation powers. Criminal defendants are of the same view. As all practicing lawyers know, who have defended persons charged with capital offenses, often the only goal possible is to avoid the death penalty. Some legislatures have required particular procedures, such as 2-stage trials and automatic appeals, applicable only in death cases. It is the universal experience in the administration of criminal justice that those charged with capital offenses are granted special considerations. This court, too, almost always treats death cases as a class apart, and the unfortunate effect of this punishment upon the functioning of the judicial process is well known. No other punishment has a similar effect. The only explanation for the uniqueness of death is its extreme severity. Death is today an unusually severe punishment, unusual in its pain, in its finality, and in its enormity. No other existing punishment is comparable to death in terms of physical and mental suffering. Although our information is not conclusive, it appears that there is no method available that guarantees an immediate and painless death. Since the discontinuance of flogging as a constitutionally permissible punishment, death remains as the only punishment that may involve the conscious infliction of physical pain. In addition, we know that mental pain is an inseparable part of our practice of punishing criminals by death, for the prospect of pending execution exacts a frightful toll during the inevitable long wait between the imposition of sentence and the actual infliction of death. As the California Supreme Court pointed out, the process of carrying out a verdict of death is often so degrading and brutalizing to the human spirit as to constitute psychological torture. Indeed, as Mr. Justice Frankfurter noted, the onset of insanity while awaiting execution of a death sentence is not a rare phenomenon. The fate of everlasting fear and distress to which the expatriation is subjected can only exist to a greater degree for a person confined in prison awaiting death. The unusual severity of death is manifested most clearly in its finality and enormity. Death in these respects is a class by itself. Expatriation, for example, is a punishment that destroys for the individual the political existence that was centuries in development, that strips the citizen of his status in the national and international political community, and that puts his very existence in jeopardy. Expatriation thus inherently entails the total destruction of the individual's status in organized society. In short, the expatriation has lost the rights to have rights. Yet demonstrably, expatriation is not a fate worse than death. Although death, like expatriation, destroys the individual's political existence and his status in organized society, it does more, for, unlike expatriation, death also destroys his very existence. There is, too, at least the possibility that the expatriate will in the future regain the right to have rights. Death forecloses even that possibility. Death is truly an awesome punishment. The calculated killing of a human being by the state involves, by its very nature, a denial of the executed person's humanity. The contrast with the plight of a person punished by imprisonment is evident. An individual in prison does not lose the right to have rights. A prisoner retains, for example, the constitutional right to the free exercise of religion, to be free of cruel and unusual punishments, and to treatment as a person for purposes of due process of law and the equal protection of the laws. A prisoner remains a member of the human family. Moreover, he retains the right of access to the courts. His punishment is not irrevocable. Apart from the common charge, grounded upon the recognition of human fallibility, that the punishment of death must inevitably be inflicted upon innocent men, we know that death has been the lot of men whose convictions were unconstitutionally secured in view of later retroactively applied holdings of this court. The punishment itself may have been unconstitutionally inflicted, yet the finality of death precluded its relief. An executed person has indeed lost the right to have rights, as one 19th century proponent of punishing criminals by death declared. When a man is hung, there is an end of our relations with him. His execution is a way of saying, "You are not fit for this world, take your chances elsewhere." In comparison to all other punishments today, then, the deliberate extinguishment of human life by the state is uniquely degrading to human dignity. I would not hesitate to hold, on that ground alone, that death is today a cruel and unusual punishment, were it not that death is a punishment of long-standing usage and acceptance in this country. I therefore turn to the second principle, that the state may not arbitrarily inflict an unusually severe punishment. The outstanding characteristic of our present practice of punishing criminals by death is the infrequency with which we resort to it. The evidence is conclusive that death is not the ordinary punishment for any crime. There has been a steady decline in the infliction of this punishment in every decade since the 1930s, the earliest period for which accurate statistics are available. In the 1930s, executions averaged 167 per year. In the 1940s, the average was 128. In the 1950s, it was 72. And in the years 1960 to 1962, it was 48. There have been a total of 46 executions since then, 36 of them in 1963 to 1964. Yet our population and the number of capital crimes committed have increased greatly over the past 4 decades. The contemporary rarity of the infliction of this punishment is thus the end result of a long-continued decline. That rarity is plainly revealed by an examination of the years 1961 to 1970, the last 10-year period for which statistics are available. During that time, an average of 106 death sentences was imposed each year. Not nearly that number, however, could be carried out, for many were precluded by commutations to life or a term of years, transfers to mental institutions because of insanity, resentences to life or a term of years, grants of new trials and orders for resentencing, dismissals of indictments and reversals of convictions, and deaths by suicide and natural causes. On January 1st, 1961, the death row population was 219. On December 31st, 1970, it was 608. During that span, there were 135 executions. Consequently, had the 389 additions to death row also been executed, the annual average would have been 52. In short, the country might, at most, have executed one criminal each week. In fact, of course, far fewer were executed. Even before the moratorium on executions began in 1967, executions totaled only 42 in 1961 and 47 in 1962, an average of less than one per week. The number dwindled to 21 in 1963, to 15 in 1964, and to 7 in 1965. In 1966, there was one execution, and in 1967, there were 2. When a country of over 200 million people inflicts an unusually severe punishment no more than 50 times a year, the inference is strong that the punishment is not being regularly and fairly applied. To dispel it would indeed require a clear showing of non-arbitrary infliction. Although there are no exact figures available, we know that thousands of murders and rapes are committed annually in states where death is an authorized punishment for these crimes. However, the rate of infliction is characterized as freakishly or spectacularly rare, or simply as rare, it would take the purest sophistry to deny that death is inflicted in only a minute fraction of these cases. How much rarer, after all, could the infliction of death be? When the punishment of death is inflicted in a trivial number of the cases in which it is legally available, the conclusion is virtually inescapable that it is being inflicted arbitrarily. Indeed, it smacks of little more than a lottery system. The states claim, however, that this rarity is evidence not of arbitrariness, but of informed selectivity. Death is inflicted, they say, only in extreme cases. Informed selectivity, of course, is a value not to be denigrated, yet presumably the states could make precisely the same claim if it were 10 executions per year, or 5, or even if there were but 1. That there may be as many as 50 per year does not strengthen the claim. When the rate of infliction is at this low level, it is highly implausible that only the worst criminals or the criminals who commit the worst crimes are selected for this punishment. No one has yet suggested a rational basis that could differentiate in those terms the few who die from the many who go to prison. Crimes and criminals simply do not admit of a distinction that can be drawn so finely as to explain, on that ground, the execution of such a tiny sample of those eligible. Certainly, the laws that provide for this punishment do not attempt to draw that distinction. All cases to whom the laws apply are necessarily extreme, nor is the distinction credible in fact. If, for example, Petitioner Furman or his crimes illustrates the extreme, then nearly all murderers and their murders are also extreme. Furthermore, our procedures in death cases, rather than resulting in the selection of extreme cases for this punishment, actually sanction an arbitrary selection. For this court has held that juries may, as they do, make the decision whether to impose a death sentence wholly unguided by standards governing that decision. In other words, our procedures are not constructed to guard against the totally capricious selection of criminals for the punishment of death. Although it is difficult to imagine what further facts would be necessary in order to prove that death is, as my brother Stuart puts it, wantonly and freakishly inflicted, I need not conclude that arbitrary infliction is patently obvious. I am not considering this punishment by the isolated light of one principle. The probability of arbitrariness is sufficiently substantial that it can be relied upon in combination with the other principles in reaching a judgment on the constitutionality of this punishment. When there is a strong probability that an unusually severe and degrading punishment is being inflicted arbitrarily, we may as well expect that society will disapprove of its infliction. I turn therefore to the third principle. An examination of the history and present operation of the American practice of punishing criminals by death reveals that this punishment has been almost totally rejected by contemporary society. I cannot add to my brother Marshall's comprehensive treatment of the English and American history of this punishment. I emphasize, however, that one significant conclusion that emerges from that history. From the beginning of our nation, the punishment of death has stirred acute public controversy. Although pragmatic arguments for and against the punishment have been frequently advanced, this long-standing and heated controversy cannot be explained solely as the result of differences over the practical wisdom of a particular government policy. At bottom, the battle has been waged on moral grounds. The country has debated whether a society for which the dignity of the individual is the supreme value without a fundamental inconsistency follow the practice of deliberately putting some of its members to death. In the United States, as in other nations of the Western world, the struggle about this punishment has been one between ancient and deeply rooted beliefs in retribution, atonement, or vengeance on the one hand, and on the other, beliefs in the personal value and dignity of the common man that were born on the democratic movement of the 18th century, as well as beliefs in the scientific approach to an understanding of the motive forces of human conduct, which are the result of the growth of the sciences of behavior during the 19th and 20th centuries. It is this essentially moral conflict that forms the backdrop for the past changes in and the present operation of our system of imposing death as a punishment for crime. Our practice of punishing criminals by death has changed greatly over the years. One significant change has been in our methods of inflicting death. Although this country had never embraced the more violent and repulsive methods employed in England, we did for a long time rely almost exclusively upon the gallows and the firing squad. Since the development of the supposedly more humane methods of electrocution late in the 19th century and lethal gas in the 20th, however, hanging and shooting have virtually ceased. Our concern for decency and human dignity, moreover, has compelled changes in the circumstances surrounding the execution itself. No longer does our society countenance the spectacle of public executions once thought desirable as a deterrent to criminal behavior by others. Today we reject public executions as debasing and brutalizing to us all. Also significant is the drastic decrease in the crimes for which the punishment of death is actually inflicted. While esoteric capital crimes remain on the books, since 1930, murder and rape have accounted for nearly 99% of the total executions, and murder alone for about 87%. In addition, the crime of capital murder has itself been limited. As the court noted in Magatha v. California, there was in this country a rebellion against the common law rule imposing a mandatory death sentence on all convicted murderers. Initially, that rebellion resulted in legislative definitions that distinguish between degrees of murder, retaining the mandatory death sentence only for murder in the first degree. Yet this new legislative criterion for isolating crimes appropriately punishable by death soon proved as unsuccessful as the concept of malice aforethought. The common law means of separating murder from manslaughter. Not only was the distinction between degree of murder confusing and uncertain in practice, but even in clear cases of first-degree murder, juries continued to take the law into their own hands. If they felt that death was an inappropriate punishment, they simply refused to convict of the capital offense. The phenomenon of jury nullification thus remained to counteract the rigors of mandatory death sentences. Bowing to reality, legislatures did not try, as before, to refine further the definition of capital homicides. Instead, they adopted the method of forthrightly granting juries the discretion which they had been exercising in fact. In consequence, virtually all death sentences today are discretionarily imposed. Finally, it is significant that 9 states no longer inflict the punishment of death under any circumstances, and 5 others have restricted it to extremely rare crimes. Thus, although the death penalty has been employed throughout our history, Trop v. Dulles, in fact, the history of this punishment is one of successive restriction. What was once a common punishment has become, in the context of a continuing moral debate, increasingly rare. The evolution of this punishment evidences not that it is an inevitable part of the American scene, but that it has proved progressively more troublesome to the national conscience. The result of this movement is our current system of administering the punishment, under which death sentences are rarely imposed and death is even more rarely inflicted. It is, of course, we the people who are responsible for the rarity both of the imposition and the carrying out of the punishment, juries expressing the conscience of the community on the ultimate question of life or death have been able to bring themselves to vote for death in a mere 100 or so cases among the thousands tried each year where the punishment is available. Governors elected by and acting for us have regularly commuted a substantial number of those sentences, and it is our society that insists upon due process of law to the end that no person will be unjustly put to death, thus ensuring that many more of those sentences will not be carried out. In sum, we have made death a rare punishment today. The progressive decline in the current rarity of the infliction of the progressive decline in and the current rarity of the infliction of death demonstrate that our society seriously questions the appropriateness of this punishment today. The states point out that many legislatures authorize death as the punishment for certain crimes, and that substantial segments of the public, as reflected in opinion polls and referendum polls, continue to support it. Yet the availability of this punishment through statutory authorization, as well as the polls and referenda, which amount simply to approval of that authorization, simply underscores the extent to which our society has in fact rejected this punishment. When an unusually severe punishment is authorized for wide-scale application, but not because of society's refusal, inflicted save in a few instances, the inference is compelling that there is a deep-seated reluctance to inflict it. Indeed, the likelihood is great that the punishment is tolerated only because of its disuse. The objective indicator of society's view of an unusually severe punishment is what society does with it, and today society will inflict death upon only a small sample of the eligible criminals. Rejection could hardly be more complete without becoming obsolete. At the very least, I must conclude that contemporary society views this punishment with substantial doubt. The final principle to be considered is that an unusually severe and degrading punishment may not be excessive in view of the purposes for which it is inflicted. This principle, too, is related to the others. When there is a strong probability that the state is arbitrarily inflicted an unusually severe punishment that is subject to grave societal doubts, it is likely that also that the punishment cannot be shown to be serving any penal purpose that could not be served equally well by some less severe punishment. The state's primary claim is that death is a necessary punishment because it prevents the commission of capital crimes more effectively than any less severe punishment. The first part of this claim is that the infliction of death is necessary to stop the individuals executed from committing further crimes. The sufficient answer to this is that if a criminal convicted of a capital crime poses a danger to society, effective administration of the state's pardon and parole laws can delay or deny his release from prison, and techniques of isolation can eliminate or minimize the danger while he remains confined. The more significant argument is that the threat of death prevents the commission of capital crimes because it deters potential criminals who would not be deterred by the threat of imprisonment. The argument is not based upon evidence that the threat of death is a superior deterrent. Indeed, as my brother Marshall establishes, the available evidence uniformly indicates, although it does not conclusively prove, that the threat of death has no greater deterrent effect than the threat of imprisonment. The states argue, however, that they are entitled to rely upon common human experience, and that experience, they say, supports the conclusion that death must be a more effective deterrent than any less severe punishment. Because people fear death the most, the argument runs, the threat of death must be the greatest deterrent. It is important to focus upon the precise import of this argument. It is not denied that many, and probably most, capital crimes cannot be deterred by the threat of punishment. Thus, the argument can apply only to those who think rationally about the commission of capital crimes. Particularly is that true when the potential criminal under this argument must not only consider the risk of punishment, but also distinguish between two possible punishments. The concern, then, is with a particular type of potential criminal, the rational person who will commit a capital crime knowing that the punishment is long-term imprisonment, which may well be for the rest of his life, but will not commit the crime knowing that the punishment is death. On the face of it, the assumption that such person exists is implausible. In any event, this argument cannot be appraised in the abstract. We are not presented with the theoretical question whether, under any imaginable circumstances, the threat of death might be a greater deterrent to the commission of capital crimes than the threat of imprisonment. We are concerned with the practice of punishment. We are concerned with the practice of punishing criminals by death as it exists in the United States today. Proponents of this argument necessarily admit that its validity depends upon the existence of a system in which the punishment of death is invariably and swiftly imposed. Our system, of course, satisfies neither condition. A rational person contemplating a murder or rape is confronted not with the certainty of a speedy death, but with the slightest possibility that he will be executed in the distant future. The risk of death is remote and improbable. In contrast, the risk of long-term imprisonment is near and great. In short, whatever the speculative validity of the assumption that the threat of death is a superior deterrent, there is no reason to believe that as currently administered, the punishment of death is necessarily to deter the commission of capital crimes. Whatever might be the case were all or substantially all eligible criminals quickly put to death, unverifiable possibilities are an insufficient basis upon which to conclude that the threat of death today has any greater deterrent efficacy than the threat of imprisonment. There is, however, another aspect to the argument that the punishment of death is necessary for the protection of society. The infliction of death, the states urge, serves to manifest the community's outrage at the commission of the crime. It is, they say, a concrete public expression of moral indignation that inculcates respect for the law and helps assure a more peaceful community. Moreover, we are told, not only does the punishment of death exert this widespread moralizing influence upon community values, it also satisfies the popular demand for grievous condemnation of abhorrent crimes and thus prevents disorder, lynching, and attempts by private citizens to take the law into their own hands. The question, however, is not whether death serves these supposed purposes of punishment, but whether death serves them more effectively than imprisonment. There is no evidence whatever that utilization of imprisonment rather than death encourages private blood feuds and other disorders. Surely, if there were such a danger, the execution of a handful of criminals each year would not prevent it. The assertion that death alone is a sufficiently emphatic denunciation for capital crimes suffers from the same defect. If capital crimes require the punishment of death in order to provide moral reinforcement for the basic values of the community, those values can only be undermined when death is so rarely inflicted upon the criminals who commit the crimes. Furthermore, it is certainly doubtful that the infliction of death by the state does in fact strengthen the community's moral code. If the deliberate extinguishment of human life has any effect at all, it more likely tends to lower our respect for life and brutalize our values. That, after all, is why we no longer carry out public executions. In any event, this claim simply means that one purpose of punishment is to indicate social disapproval of crime. To serve that purpose, our laws distribute punishments according to the gravity of the crimes and punish more severely the crimes society regards as more serious. That purpose cannot justify any particular punishment as the upper limit of severity. There is, then, no substantial reason to believe that the punishment of death as currently administered is necessary for the protection of society. The only other purpose suggested, only that is independent of protection for society, is retribution. Shortly stated, retribution in this context means that criminals are put to death because they deserve it. Although it is difficult to believe that any state today wishes to proclaim adherence to naked vengeance, the states claim, in reliance upon its statutory authorization, that death is the only fit punishment for capital crimes, and that this retributive purpose this retributive purpose justifies its infliction. In the past, judged by its statutory authorization, death was considered the only fit punishment for the crime of forgery, and the first federal criminal statute provided a mandatory death penalty for that crime. Obviously, concepts of justice change. No immutable moral order requires death for murderers and rapists. The claim that death is a just punishment necessarily refers to the existence of certain public beliefs. The claim must be that for capital crimes, death alone comports with society's notion of proper punishment. As administered today, however, the punishment of death cannot be justified as a necessary means of exacting retribution from criminals. When the overwhelming number of criminals who commit capital crimes goes to prison, it cannot be concluded that death serves the purpose of retribution more effectively than imprisonment. The asserted public belief that murderers and rapists deserve to die is flatly inconsistent with the execution of a random few. As the history of the punishment of death in this country shows, our society wishes to prevent crime. We have no desire to kill criminals simply to get even with them. In sum, the punishment of death is inconsistent with all four principles. Death is an unusually severe and degrading punishment. There is a strong probability that it is inflicted arbitrarily. Its rejection by contemporary society is virtually total, and there is no reason to believe that it serves any penal purpose more effectively than the less severe punishment of imprisonment. The function of these principles is to enable a court to determine whether a punishment comports with human dignity. Death, quite simply, does not. When this country was founded, memories of the Stuarts' horrors were fresh and severe corporal punishments were common. Death was not then a unique punishment. The practice of punishing criminals by death, moreover, was widespread and by and large acceptable to society. Indeed, without developed prison systems, there was frequently no workable alternative. Since that time, successive restrictions imposed against the background of a continuing moral controversy have drastically curtailed the use of this punishment. Today, death is a uniquely and unusually severe punishment. When examined by the principles applicable under the Cruel and Unusual Punishments Clause, death stands condemned as fatally offensive to human dignity. The punishment of death is therefore cruel and unusual, and the states may no longer inflict it as a punishment for crimes. Rather than kill an arbitrary handful of criminals each year, the state will confine them in prison. The state thereby suffers nothing and loses no power. The purpose of punishment is fulfilled, crime is repressed by penalties of just, not tormenting severity, its repetition is prevented, and hope is given for the reformation of the criminal. I concur in the judgments of the court. Mr. Justice Stewart concurring, the penalty of death differs from all other forms of criminal punishment, not in degree, but in kind. It is unique in its total irrevocability. It is unique in its rejection of rehabilitation of the convict as a basic purpose of criminal justice. And it is unique, finally, in its absolute renunciation of all that is embodied in our concept of humanity. For these and other reasons, at least two of my brothers have concluded that the infliction of the death penalty is constitutionally impermissible in all circumstances under the 8th and 14th Amendments. Their case is a strong one, but I find it unnecessary to reach the ultimate question they would decide. The opinions of other justices today have set out in admirable and thorough detail the origins and judicial history of the Eighth Amendment's guarantee against the infliction of cruel and unusual punishments, and the origin and judicial history of capital punishment. There is thus no need for me to review the historical materials here, and what I have to say can, therefore, be briefly stated. Legislatures, state and federal, have sometimes specified that the penalty of death shall be the mandatory punishment for every person convicted of engaging in certain designated criminal conduct. Congress, for example, has provided that anyone convicted of acting as a spy for the enemy in time of war shall be put to death. The Rhode Island legislature has ordained the death penalty for a life-term prisoner who commits murder. Massachusetts has passed a law imposing the death penalty upon anyone convicted of murder in the commission of a forcible rape. An Ohio law imposes the mandatory penalty of death upon the assassin of the President of the United States or the governor of the state. If we were reviewing death sentences imposed under these or similar laws, we would be faced with the need to decide whether capital punishment is unconstitutional for all crimes and under all circumstances. We would need to decide whether a legislature, state or federal, could constitutionally determine that certain criminal conduct is so atrocious that society's interest in deterrence and retribution wholly outweighs any considerations of reform or rehabilitation of the perpetrator, and that, despite the inconclusive empirical evidence, only the automatic penalty of death will provide maximum deterrence. On that score, I would say only that I cannot agree that retribution is a constitutionally impermissible ingredient in the imposition of punishment. The instinct for retribution is part of the nature of man, and channeling that instinct in the administration of criminal justice serves an important purpose in promoting the stability of a society governed by law. When people begin to believe that organized society is unwilling or unable to impose upon criminal offenders the punishment they deserve, then there are sown the seeds of anarchy, of self-help, vigilant justice, and lynch law. The constitutionality of capital punishment in the abstract is not, however, before us in these cases, for the Georgia and Texas legislatures have not provided that the death penalty shall be imposed upon all those who are found guilty of forcible rape, and the Georgia legislature has not ordained that death shall be the automatic punishment for murder. In a word, neither state has made a legislative determination that forcible rape and murder can be deterred only by imposing the penalty of death upon all who perpetrate those offenses. As Mr. Justice White so tellingly puts it, the legislative will is not frustrated if the penalty is never imposed. Instead, the death sentences now before us are the product of a legal system that brings them, I believe, within the very core of the Eighth Amendment's guarantee against cruel and unusual punishments, a guarantee applicable against the states through the 14th Amendment. In the first place, it is clear that these sentences are cruel in the sense that they excessively go beyond, not in degree, but in kind, the punishments that the state legislatures have determined to be necessary. In the second place, it is equally clear that these sentences are unusual in the sense that the penalty of death is infrequently imposed for murder, and that its imposition for rape is extraordinarily rare. But I do not rest my conclusion upon these two propositions alone. These death sentences are cruel and unusual in the same way that being struck by lightning is cruel and unusual. For of all the people convicted of rapes and murders in 1967 and 1968, many just as reprehensible as these, the petitioners are among a capriciously selected random handful upon whom the sentence of death has in fact been imposed. My concurring brothers have demonstrated that if any basis can be discerned for the selection of these few to be sentenced to die, it is the constitutionally impermissible basis of race. But racial discrimination has not been proved, and I put it to the one side. I simply conclude that the 8th and 14th Amendments cannot tolerate the infliction of a sentence of death under legal systems that permit this unique penalty to be so wantonly and so freakishly imposed. For these reasons, I concur in the judgments of the court. Mr. Justice White concurring. The facial constitutionality of statutes requiring the imposition of the death penalty for first-degree murder, for more narrowly defined categories of murder, or for rape would present quite different issues under the Eighth Amendment than are posed by the cases before us. In joining the court's judgment, therefore, I do not at all intimate that the death penalty is unconstitutional per se, or that there is no system of capital punishment that would comport with the Eighth Amendment. That question, ably argued by several of my brethren, is not presented by these cases and need not be decided. The narrow question to which I address myself concerns the constitutionality of capital punishment statutes under which 1. The legislature authorizes the imposition of the death penalty for murder or rape. 2. The legislature does not itself mandate the penalty in any particular class or kind of case. That is, legislative will is not frustrated if the penalty is never imposed, but delegates to judges or juries the decisions as to those cases, if any, in which the penalty will be utilized. And 3. Judges and juries have ordered the death penalty with such infrequency that the odds are now very much against imposition and execution of the penalty with respect to any convicted murderer or rapist. It is in this context that we must consider whether the execution of these petitioners would violate the Eighth Amendment. I begin with what I consider a near truism, that the death penalty could so seldom be imposed that it would cease to be a credible deterrent or measurably to contribute to any other end of punishment in the criminal justice system. It is perhaps true that no matter how infrequently those convicted of rape or murder are executed, the penalty so imposed is not disproportionate to the crime, and those executed may deserve exactly what they received. It would also be clear that executed defendants are finally and completely incapacitated from again committing rape or murder or any other crime. But when imposition of the penalty reaches a certain degree of infrequency, it would be very doubtful that any existing general need for retribution would be measurably satisfied. Nor would it be said with confidence that society's need for specific deterrence justifies death for so few when so many in like circumstances life imprisonment or shorter prison terms are judged sufficient, or that community values are measurably reinforced by authorizing a penalty so rarely invoked. Most important, a major goal of the criminal law to deter others by punishing the convicted criminal would not be substantially served where the penalty is so seldom invoked that it ceases to be the credible threat essential to influence the conduct of others. For present purposes, I accept the morality and utility of punishing one person to influence another. I accept also the effectiveness of punishment generally, and need not reject the death penalty as a more effective deterrent than a lesser punishment. But common sense and experience tell us that seldom enforced laws become ineffective measures for controlling human conduct, and that the death penalty, unless imposed with sufficient frequency, will make little contribution to deterring those crimes for which it may be exacted. The imposition and execution of the death penalty are obviously cruel in the dictionary sense, but the penalty has not been considered cruel and unusual punishment in the constitutional sense because it was thought justified by the social ends it was deemed to serve. At the moment that it ceases realistically to further these purposes, however, the emerging question is whether its imposition in such circumstances would violate the Eighth Amendment. It is my view that it would, for its imposition would then be the pointless and needless extinction of life with only marginal contributions to any discernible social or public purposes. A penalty with such negligible returns to the state would be patently excessive and cruel and unusual punishment, violative of the Eighth Amendment. It is also my judgment that this point has been reached with respect to capital punishment as it is presently administered under the statutes involved in these cases. Conceitedly, it is difficult to prove as a general proposition that capital punishment, however administered, more effectively serves the ends of the criminal law than does imprisonment. But, however that may be, I cannot avoid the conclusion that as the statutes before us are now administered, the penalty is so infrequently imposed that the threat of execution is too attenuated to be of substantial service to criminal justice. I need not restate the facts and figures that appear in the opinions of my brethren, nor can I prove my conclusion from these data. But, like my brethren, I must arrive at judgment, and I can do no more than state a conclusion based on 10 years of almost daily exposure to the facts and circumstances of hundreds and hundreds of federal and state criminal cases involving crimes for which death is the authorized penalty. That conclusion, as I have said, is that the death penalty is exacted with great infrequency even for the most atrocious crimes, and that there is no meaningful basis for distinguishing the few cases in which it is imposed from the many cases in which it is not. The short of it is that the policy of vesting sentencing authority primarily in juries, a decision largely motivated by the desire to mitigate the harshness of the law and to bring community judgment to bear on the sentence as well as guilt or innocence, has so effectively achieved its aims that capital punishment within the confines of the statutes now before us has, for all practical purposes, run its course. Judicial review, by definition, often involves a conflict between judicial and legislative judgment as to what the Constitution means or requires. In this respect, Eighth Amendment cases come to us in no different posture. It seems conceded by all that the amendment imposes some obligations on the judiciary to judge the constitutionality of punishment, and that there are punishments that the amendment would bar whether legislatively approved or not. Inevitably, then, there will be occasions when we will differ with Congress or state legislatures with respect to the validity of punishment. There will also be cases in which we shall strongly disagree among ourselves. Unfortunately, this is one of them. But as I see it, this case is no different in kind from many others, although it may have wider impact and provoke sharper disagreement. In this respect, I add only that past and present legislative judgment with respect to the death penalty loses much of its force when viewed in light of the recurring practice of delegating sentencing authority to the jury, and the fact that a jury, in its own discretion and without violating its trust or any statutory policy, may refuse to impose the death penalty no matter what the circumstances of the crime. Legislative policy is thus necessarily defined not by what is legislatively authorized, but by what juries and judges do in exercising the discretion so regularly conferred upon them. In my judgment, what was done in these cases violated the Eighth Amendment. I concur in the judgments. Okay, we'll stop there for now, and I'll be out with part 2 tomorrow. Thank you.